Recorded.
Private English law was transported around the world by using law of domicile and private international law. In 1535, the monarchy created what's called statute of uses. Then just before 1600s, they started creating the trading companies. And this is the link that's missing in the law books. Because the trading companies were a company to themselves, which did not require an actual act from the actual government, from the monarchy, except for to create the actual trading company itself and give it its right to do whatever it was going to do. So an English subject is always, once you swear allegiance to a monarchy, that allegiance stands until you've actually terminated it. So the English law of domicile and law of private international law, which is equity law because it was created after the 1600s. And that'll become evident with the trading companies and the admiralty law that was created with the trading companies and gone to sea. So since all English individuals, everything that they take, everybody that's in fee simple and subject to the monarchy or subject to the English common law, everything that those individuals take, including the government, they're taking it in right of the crown. So it's actually that crown's thing. So because these individuals did not release their allegiance to the monarchy, and never have, like even the United States, they have never released their allegiance to the monarchy. So when the trading companies started traveling around the world to like India and Canada, United States, right, through the other trading companies, because they used the East Indian Company to go to like India and that part of the world. They used the Northwest Company and there's another one I can't remember, and the Hudson's Bay Company to send all their subjects to this hemisphere, like where Canada, the United States is, and the East Indian Company dealt with everything on that side of the planet, and so we can see that by the English assumption, by the English subject coming to these lands. Because you got to remember, this started in 1600s, and not until 1925 did they have enough English subjects on these other territories that got into an agreement with the inhabitants that are on those lands to grant them the land. So let's say I'm coming over here on the first boat from an English colony, and I'm an English subject. I stay here and the boat goes back, but those indigenous people start getting into agreements with me to give me land. Well, they didn't actually give that land to me. They gave it to the crown. And when they come and ask me for that land back, I can't give it. Only the crown can give it, because I took it in the name of the crown, and only the crown has the authority to give it back. So that's basically how they got all the people's land. Right, all the inhabitants, the indigenous people, right? They got into agreements with all these indigenous people because indigenous people were in a natural law jurisdiction, and this is an equitable jurisdiction of those that only have a use for a fee. So when these two collided, and the people in the natural jurisdiction did not understand what was happening, they were giving their natural rights away to the monarchy and becoming subject. Because once these indigenous people had no more land mass left, they were automatically incorporated into the corporation, and now they're fee simple and subject to the monarchy, right? Where they don't have any lands, and where they're got a use for a fee for those lands. So all these indigenous, everybody, doesn't matter what color you are or anything else, we're those class of subjects about Métis, right? American, white, black, right? Chinese, all these different labels, they're only in English law. and they're for classes of subjects. Because if we look, every one of these territories are bound by municipal law. So it took from the 1600s till 1925 for them to have a big enough impact on the lands with agreements from those indigenous people, where they had so many lands now where they started municipalities, right, and incorporated underneath the crown because they're all subjects. That's what actually created the equitable law of the land, which is the law of property 1925, but it's still equity. I hope this is starting to make some sense. So since then, all this equity, where they didn't have a law of the land before, now they have a law of the land because the inhabitants, right, decided to create a municipal corporation and then incorporate themselves and their lands into those that corporation. That is not the monarchy, right? The monarchy created that corporation, right? That it's not the monarchy itself. They're completely different, and that's what a trust is only between the donor and donee. Everybody else is not part of the trust. So that's how they transferred English law around the world, and that's how come when people are thinking, well, that's impossible, right? That English law took over the world. But when we look at jurisdiction, and that subject matter jurisdiction is the land and who owns it, we start looking at the law of domicile. They specifically state that that's how jurisdiction is established. That if I come over here and you grant something to me, because you're not actually granting it to me, because I don't even have the capacity to own something, me being in fee simple, that means that it's actually going to my boss, right, which is the monarchy, the crown. So that's basically the gist to how they transported the English law around the globe without anybody even catching on to it. And that's why there's that break in the law books, because they did it through a trading company of the sea. So because nobody needed it, the sea has no subjects. So if they were trying to make a trading company within the jurisdiction of, let's say, the province of Manitoba, right? The people in Manitoba would have had to have enact those laws. But because she's created this jurisdiction on sea where there is nobody else, it's strictly her thing. So she just had to create the actual jurisdiction, and everybody that jumped on the boat are still her subjects, right? Does anybody have any questions about that part? Can anybody hear me?
Sounds all straightforward to me.
Yeah,
I followed that.
No problem. Such East India Trading Company later became the Crown.
It's always been the crown, because they're all crown corporations. All corporations are created by the crown. Nobody else in English law has the ability to create anything, because you can't own anything. That's why the monarchy is the only one that can write the law, right? And then she writes the law to allow her corporation to create another law, right? So the only reason why governments and corporations can create laws is because she gave them the capacity to do it. Go ahead, David.
Now that for the Indian bands that did not sign a treaties, but if they accepted any form of payment for use, let's say a percentage, that then puts them into fee simple automatically. Would that how the contract would work?
Yes, because it's titles by purchase. All they have to do is be willing to give it up and accept going and purchasing things as that corporate person, because they no longer have any lands. So because they're because all the, let's say, the Indian reserves now, they're Indian reserves. So that Indian reserve is created by the federal government, right? So because the division of powers in Canada and the British North American Act, if you're a part of a band or have Métis rights and stuff like that, I believe you're going to have to do 2 releases, because you have a provincial birth certificate, but you're also a federal class of subject, right? So you also have to fight the Governor General, right, and tell him, like, no, I'm not being your class of subject whatsoever, right? Because in Canada, the federal jurisdiction is the jurisdiction that deals with the Métis people and the Aboriginal, right? Because that's how they wrote it into the British North American Act, right? So United States jurisdictions are going to be set up different for how their internal laws got written, right? Because you'd have to go back to the Statute of Virginia that created the United States by the monarchy's grant, and that will start telling you about that, right? And UK, we have to go back to the original grant, I believe, of Parliament in 1600s to get UKs, right? Because the United Kingdom is the oldest English territory there is, right? Only from there did they transported the law. So the UK would have, the Parliament, all that stuff would have happened in the Great Revolution of 1600s, because that's when Parliament got that right from the monarchy to start creating their own laws, and where now the monarchy has to accept it from the Parliament, right? Where before it was completely reversed, where the monarchy made all the laws and the people didn't have a say about it, right? The Parliament could bitch and whine all they wanted to, but let's look at the history of the crown, or the monarchy, the English monarch, right? It's just you can see it all throughout there, right? So is that
yeah? So
that?
But yeah, so non-treaty Indians are then just another capacity of subject, really.
That's right. It's just an extra contract on top of it. So it's just something else. Something else, if you're in that class of subject, that you're going to have to deal with.
Right.
Does anybody else have anything to add for transporting English law? Anything relevant? Any questions or anything? No, cool.